Hello there and welcome to the Doctrine of Consideration in English Contract Law. Welcome to Part 3 of the Law for You Contract Law series. Part 1 was offer, Part 2 was acceptance, and today we're looking at consideration, the third key element in the formation of a binding contract. We're tackling the badge of enforceability, the doctrine of consideration. Does English contract law care if I just give you my car? No, it doesn't. And why does it not care? Because it's simply a gift. It's a one-way benefit to you, which causes me a detriment. However, there's no detriment to you, which causes me to have no benefit. So based on the doctrine of consideration, if I change my mind tomorrow, you cannot sue me for specific performance and try and convince the court to enforce me to give you my car. So let's put a different spin on it. What about if you were to pay me £1 for my car? And that entirely is a different story. That £1 means we have a legal exchange, and that exchange has the makings of a legally binding contract. Because although it may not be equivalent, if you give me £1 for a £40,000 car, consideration doesn't have to be equivalent. But there must be a benefit and a detriment to both parties. So what exactly is consideration? The classic definition comes from the case of Currie and Misa from 1875. The court defined it as some right, interest, benefit or profit accruing to the one party, or some forbearance, detriment, loss of responsibility given, suffered or undertaken by the other. In plain English, it's a bargain, it's an exchange, a swap of promises. English contract law doesn't tend to enforce gratuities. For a contract to exist, there must be a quid pro quo, something in exchange for something. Usually it's fairly straightforward. I give you my goods, my detriment your benefit, and you pay me, your detriment my benefit. And that's simple and straightforward. But as always with the law, it can get complicated when we consider what that something actually has to be. So let's break down 3 golden rules of consideration. Rule 1, past consideration is no consideration at all. That basically means you cannot use something you've already done, something that's already passed, before the promise was made, to pay for that promise. The leading case here is McArdle from 1951. A wife carried out some improvements on a house. After the work was completed, her husband's family signed a document promising to pay her £488 for the work. But later on, the family refused to pay her. The Court of Appeal agreed with the family. Why, I hear you asking? Because the work was already done. The consideration by the wife was already in the past. The promise to pay came after the act. So legally, the work was a voluntary gift. If the family had offered to pay the £488 before the wife had done the work, it would have been enforceable. But they didn't. They offered after. Henceforth, the court ruled it was unenforceable, as there was no consideration passing from the wife to the family in exchange for the payment offered of £488. However, of course, there's an exception to this rule, and it goes right back to a man on death row in 1615. The case is Lampleigh and Braithwait. Braithwait had killed a man and asked Lampleigh to do everything he could to secure a pardon for Braithwait from the king. Lampleigh worked tirelessly, rode around the country, and eventually he secured the pardon. After the pardon was secured, so it's an action already taken, Braithwait was so happy he promised to pay Lampleigh £100, but he never paid. So the circumstances are similar to the last case, whereby Lampleigh put in the effort and secured the pardon before Braithwait offered to pay him the £100, so one would assume it was unenforceable. However, when Lampleigh sued, the court said, yes, the act was in the past, but it was done at the defendant's specific request. Because Braithwait had asked for the service, it was implied from the start that it would be paid for in some form of consideration, in this case, the £100. So if you do something at somebody's request, and it's the sort of thing that would normally be paid for in one way or another, a later promise to pay an amount just fixes the price. Because you're acting on a request already put to you, that makes it legally binding, even though the consideration was offered after the event had already taken place or the action had been taken. Then there's rule number 2. Consideration must be sufficient, but it need not be adequate. Granted, that sounds like a riddle. What it actually means is, consideration must have some value in the eyes of the law. It must be sufficient. It doesn't have to be equal nor adequate in relation to the thing you may be purchasing. Remember me offering to sell you my car for £1? Again, perfectly fine, because the courts will not correct a bad bargain. If you want to sell your house for peppercorn, that's entirely up to you. Or if I want to sell my car for £1, that's entirely up to me. Courts cannot intervene with regards to the equivalence of the bargain. The most famous example of this involves chocolate wrappers, in the case of Chappell & Co. and Nestle from 1960. Nestle ran a promotion. Send us 1 shilling and sixpence plus 3 chocolate bar wrappers and we'll send you a hit record. The copyright holders of the record sued. They argued the wrappers were worthless trash and shouldn't count as part of the sale when calculating the royalties. The House of Lords disagreed. They held that the wrappers were part of the consideration. Lord Somerville famously said, "A contracting party can stipulate for what consideration he chooses. A peppercorn does not cease to be good consideration if it is established that the promisee does not like pepper and will throw away the peppercorn. So legally, trash can be cash, as long as it's part of the deal, which is just as well. Otherwise scrap merchants would have serious problems enforcing contracts." And then there's rule number 3. This is the big one. Existing duties. In essence, this means that performing a duty that you're already contracted to do is not good consideration. If I employ you to paint my wall for £100 and halfway through you say, "I'm not going to finish unless you pay me another 50, if I agree, can you enforce that extra £50? Generally, no you can't. You were already legally obliged to paint the wall when you agreed to do it for the £100. You haven't given me anything new. The classical authority for this case is Stilk and Myrick from 1809. The ship was sailing from London to the Baltics. 2 sailors deserted at one of the ports they stopped at. The captain promised the remainder of the crew that if they all worked a bit harder and got the ship home, they could split the deserters' wages. So they got the ship home. And surprise, surprise, when they landed ashore, the captain refused to pay them any extra money. They ended up in court, and the court said the promise was unenforceable. The crew were already employed to sail the ship in all emergencies. 2 men leaving could be regarded as a normal emergency. So in actual reality, they did nothing extra other than what they were already contracted to do. So if you're at work and one of your colleagues is off sick and you decide to take it upon yourself to do some of their work to help out your boss, you can't turn around afterwards and ask for extra or time off in lieu because you did it, unless of course your boss already agreed beforehand and covering for other staff isn't part of your contracted job. However, if we compare this to Hartley and Ponsonby, 1857, which are similar facts to the last case, but in this instance half of the crew deserted at one of the ports they stopped at, this action made it dangerous to sail. So the court said, yes, it is binding. Why? Because it was dangerous to sail with only half of the crew, so the remainder of the crew, by working to the extent they would have had to work to get the ship back, would have undertaken dangerous duties, which is over and above what they would be contracted to do. So by working on a dangerously undermanned ship, they went above and beyond their contracted duties, which was regarded as fresh consideration. So in that case, the crew succeeded in court. But here's the game changer for you. Now for 180 years, Stilk and Myrick was the cast iron rule we stood by. You can't get paid extra for doing your job. But then came 1991, and the case that every law student needs to know. Williams against Roffey Brothers and Nichols Contractors Limited. Roffey Brothers were builders refurbishing flats. They subcontracted the carpentry to Williams for £20,000. Williams made an error and priced the job too low. He ran out of money halfway through. Roffey Brothers were worried if Williams stopped, Roffey would miss their completion deadline and would have to pay a penalty to the main client. So Roffey promised Williams an extra £10,300 if they could finish by the deadline. Williams finished within the target deadline, but Roffey refused to pay the bonus, and they used Stilk and Myrick as their defence, claiming that Williams only did what he was originally contracted to do. Which on the face of it, you think, yeah, that's a fair point. He didn't do any extra work, he's the one who underpriced it, so why should Roffey Brothers have to pay more? However, the Court of Appeal took a pragmatic commercial approach, and they said Roffey Brothers did indeed receive a practical benefit in exchange for paying the extra money. They chose to keep Williams on the job, they avoided the hassle of having to find a new carpenter, crucially they avoided the penalty clause and the financial penalties in the agreement with their existing client. So these practical benefits were indeed enough to count as valid consideration. So in the modern commercial world, preventing a problem can be just as valuable as offering new consideration in a contract in exchange for a higher payment. So Williams and Roffey suggest that courts can be flexible. Yeah? Well, not when it comes to paying a debt. If you owe me £1,000 and I say, look, give me 500 and we call it quits, and you pay me the 500, Can I sue you for the rest? Yes, I absolutely can. This is the rule from Pinnell's case in 1602, confirmed by the House of Lords in Foakes and Beer in 1884. Mrs. Beer had a judgment against Dr. Foakes. They signed an agreement. If he paid the main sum in instalments, she wouldn't sue for the interest. He paid the main sum, as per the instalments agreed, but then Mrs. Beer still sued him for the interest. Now that can't be fair, I hear you saying. But the House of Lords said, yeah, she wins. Payment of a lesser sum is never satisfaction for the whole. Dr. Foakes was already obliged to pay the full amount. Paying less provided no new consideration. In 1995, in a case called Selectmove, a company tried to use the Williams and Roffey argument against the taxman. They argued the taxman got a practical benefit by accepting instalment payments as opposed to putting their company into liquidation. The Court of Appeal said, we can see your logic, but our hands are indeed tied, because the House of Lords decision in Foakes and Beer trumps the Court of Appeal decision in Williams and Roffey, so a practical benefit works for goods and services, but it does not work for outstanding debts, in this case to the taxman. Now we'll move on to the shield known as Promissory Estoppel. So the strict rule in the last case talked about regarding debts does seem harsh, doesn't it? It permits creditors to go back on their word. The law of equity thought so too, and this brings us to one of the most famous doctrines in English contract law, Promissory Estoppel. The main case is Central London Property Trust Limited and High Trees House Limited, 1947. It was World War II, London was being bombed. The tenants of a block of flats couldn't pay the full rent. The landlord agreed to reduce the rent by half, from $2,500 to $1,250 a year. After the war finished, the flats were all full again, and the landlord decided to sue for the full rent. Mr. Justice Denning, a legend of the 20th century, stepped in. He agreed. The landlord was entitled to the full rent now the war was over. However, the landlord was estopped, or prevented, from claiming the back rent for the war years. Why? Because 1, they made a clear promise, 2, the tenant relied on that promise, and 3, it would be inequitable or unfair to allow the landlords to go back on their word. However, there is a catch. Promissory estoppel may only be used as a shield, not as a sword. This comes from Combe, 1951. You can use it to defend yourself if you are sued by virtue of the promise made to you that they wouldn't sue you, but you may not use it to start a lawsuit. So let's wrap this up. English law is very cynical. It just doesn't trust generosity, doesn't really like getting involved with gifts. To enforce a promise, you need consideration, value moving from you to the other party, and vice versa. It can be a pound coin, a sweet wrapper, a practical benefit, or even a request for a job to be done. It cannot be something you've already done in the past, and if you owe the money, don't rely on a handshake deal unless you give them something extra in return. Otherwise you may find yourself like Dr. Foakes, paying the full bill plus the interest, irrelevant of whatever you may have agreed after. So consideration must be sufficient, but it doesn't have to be equivalent. Consideration may not be in the past, unless it was something specifically requested to be done, and promissory estoppel is a shield, not a sword. In the next video, we're going to be looking at intention to create legal relations, how contracts stand in domestic situations, and the importance of both parties intending for the contract to be legally binding. Don't forget to like and share this video to anybody you think might find it useful, and hit the subscribe button to be notified of future publications in our legal learning series and upcoming videos on English legal and political topics. Thanks for watching. See you next time.